Welcome back to another lesson in the law of contracts. In this lesson, what we're going to do is talk about the parole evidence rule. And this is just something of a minor point that we need to make reference to when examining contractual terms. We'll talk about what the parole evidence rule is, the general principle therein, and then talk about a couple of exceptions to this principle. So, essentially, what the parole evidence rule does is it provides the courts with an indication as to the admissibility of evidence which is not incorporated into the written contract itself. So when you're examining as a court the various different terms of a contract, the question that you have to think about is, if there are things and there are points and there are things that may or may not be incorporated into the contract itself, to what extent is evidence that isn't in the contract admissible to the terms of the contract? Well, essentially, a contract which is written down is presumed to be all-encompassing, and anything which is not in the contract itself is considered to have not been an intended term, and so as a result of which it would not be valid. So, obviously, there's a little bit of an exception, a little bit of a difference when we're talking about oral agreements and agreements which are not written down. But essentially, the point that it is trying to make here is that there is a basic presumption of contracts that where they are written down, the writing that exists is the all-encompassing beginning and the end of the contract, and that there are no other terms that exist outside of this contract. This obviously is useful for courts to basically draw the line at what may or may not be included into a contract. If this rule didn't exist, if it was just presumed that anything could, even if it isn't written down, can be still part of the contract, then parties will continue to make various additional claims as to what may or may not be in their contract, which goes beyond the scope of what is written down, which of course would eventually lead to a bit of lunacy. So, the parole evidence rule essentially tells us that when it comes to contractual disputes, something known as parole evidence, evidence which is not incorporated into the contract, is presumed to be and is deemed to be inadmissible. And so there are notable exceptions, which includes the previously examined cases from previous lessons, but it also, like I said, will include other exceptions too. And I just want to talk a little bit about the J. Evans and Sons Portsmouth case from 1976. In this case, an agreement was made between the parties for the shipping of products into the United Kingdom. A contract in writing and a clause gave the transporters a certain amount of discretion in respect of, quote, the procedure to be followed in the handling and transportation of the goods. So an agreement was made for the shipping of these products, and the handlers, the people who were actually doing the shipping themselves, had a bit of discretion in relation to the procedure to be followed in the handling of transportation. So it wasn't determined and specifically cited where and how these products would be shipped, but just that they would be shipped. In addition to the term that was in writing here, the parties had actually come to an oral agreement that they had wanted their products to be transported below deck, just a specific requirement, something which actually did not happen in the conduct of the shipping. They failed to follow along with this particular request. And because the items were shipped above deck, the container actually would fall overboard and be lost, obviously causing quite a lot of financial loss. The claimants would then sue on the basis that the defendants had breached their contracts in terms of carriage. So their breach of contract came from the oral agreement. It came from their alleged breach of the oral agreement because they wanted it to be shipped and transported below deck, but it had not been shipped and transported below deck. And of course, if it had been shipped below deck, they probably wouldn't have gone overboard. It was held that the oral agreement which was made between the parties, despite actually not being made in writing, was in fact incorporated into the terms of the contract, representing something of an exception to the parole evidence rule. Because if you were to just take the parole evidence rule at its face, you would come to the conclusion that if this oral agreement is not part of the contract, then it is deemed to be inadmissible. Well, what the court did was, instead of a very strict application of the parole evidence rule, they took an holistic examination. They examined a set of holistic circumstances and evidence rather than just which was written down in the terms. And so from that conclusion, they came to the view that the parole evidence rule was not really applicable, or this represented something of an exception to said rule. Other exceptions include various different instances where the parole evidence, generally evidence which is not incorporated into the contracts, may be admissible for contributing to evidential claims. Parole evidence, for example, can be used for equitable purposes. So, for example, where there is not an accurate representation of an agreement, there is the equitable remedy of rectification. According to the case of Hutton and Warren from 1836, evidence which is not incorporated into the contract can be admissible, quote, to annex incidences to written contracts, in matters which, with respect to which they are silent. What the point here is that essentially, if you have a contract that is all written down and there is some parole evidence, there is evidence that exists outside of the contract, and this parole evidence actually seeks to and exists and it actually contributes to an area of the contract to which there is silence, to which there is no actual writing and no actual conduct for how that should act, then the parole evidence could actually be used to basically fill in the gaps, to find and to essentially annex incidents to written contracts in matters with respect to which there is silence. It could also be admissible for the determination of a time period of a contract. Sometimes the time period is not specifically cited in a contractual arrangement, and so parole evidence may be determinative in that regard as well.